Hello and welcome to today's clinic, Advanced Care Planning, presented by Legal Aid of North Carolina and Vidant Health. This clinic will help you prepare a health care power of attorney and a living will to ensure that your health care and end-of-life wishes are carried out in case you become seriously ill or injured and are unable to communicate your wishes to your health care provider. First, we want to clarify a few things before getting started. A health care power of attorney is different from a general power of attorney. A health care power of attorney allows you to appoint someone to make decisions about your medical care if you are unable to make those decisions yourself. A general power of attorney allows you to appoint someone to carry out your wishes with respect to other matters. For example, you can appoint someone to handle your banking or make a purchase, or enter into a contract on your behalf. This clinic is about health care powers of attorney only. Second, a living will is not the same thing as a last will and testament. A living will controls your end-of-life medical care while you are living. A last will and testament controls how your property passes after your death. This clinic is about living wills only. Now let's get started. There are two primary advance directives, a health care power of attorney and a living will. Why are these directives important? They are important because they allow you or someone you trust to make medical decisions for you in case you're unable to make them yourself. Preparing them now allows you to consider and discuss your choices with your family and close friends before you become seriously ill. It may be helpful to discuss your options with your healthcare providers as well. These are important decisions and you want to give them careful consideration. Let's talk about the health care power of attorney first. The health care power of attorney designates someone, usually a close friend or family member, to make health care decisions for you in the event that you're unable to communicate your wishes to your health care providers. This person is called your health care agent. In order to serve as your health care agent, the person you choose must be competent and over the age of 18. The person may not be your healthcare provider or someone employed by your healthcare provider. A healthcare agent is able to make all of your healthcare decisions for you, including but not limited to decisions about physical and mental health treatment, choosing care providers and healthcare facilities, sharing your medical information with others, starting or stopping life-prolonging measures, organ donation and disposition of your body after death. Your healthcare agent should be someone you trust. Making potential life or death decisions on behalf of a loved one can be difficult and stressful. You want to make certain that the person you choose as your healthcare agent is able and willing to make these decisions for you. It is important to understand that your healthcare power of attorney goes into effect only when your doctor determines that you are no longer able to make health decisions on your own. Until that time, you may still make decisions for yourself. Now, let's talk about a living will. A living will controls your end-of-life medical care. It allows you to decide ahead of time whether you want to receive life-prolonging measures under the following circumstances. You have an incurable condition that will result in your death within a short period of time. You are unconscious and your doctors do not believe that you will regain consciousness. You have advanced dementia or have suffered an irreversible loss of brain function. What is a life-prolonging measure? A life-prolonging measure is medical treatment that extends your life, even if the doctor believes there is no hope for recovery. Medical treatment may include, but is not limited to, the use of a breathing machine, dialysis, artificial nutrition, food, and hydration, water, antibiotics, or pain medication. By preparing a living will, you can instruct your doctor to withhold life-prolonging measures or limit the types of life-prolonging measures you receive. For example, you may request that you only receive artificial nutrition or hydration. Or you may request that you receive only pain medication to keep you comfortable. You may instruct your healthcare provider to use any combination of life-prolonging measures or none at all. The choice is yours. Now let's talk about how to complete your healthcare power of attorney and living will. Starting on page 12 in your toolkit. The first page is titled Part A, Healthcare Power of Attorney, Choosing a Healthcare Agent. Print your name and date of birth. In paragraph 1, print the name, address, and contact information for the person you want to act as your healthcare agent. You may also designate a second choice if your first choice is unable or unwilling to serve as your healthcare agent. Paragraph 2 allows you to include any special instructions stating your specific wishes or restricting the authority of your healthcare agent. For example, the instructions can state what, if any, life-prolonging measures you would like. If you do not have any special instructions, you should mark completely through this section. Paragraph 3 allows you to state your desire to donate your organs after your death. You must initial where indicated if you want your healthcare agent to be able to donate your organs. The second part of the document, Part B, is your living will. If you do wish to receive life-prolonging measures without restriction, then you should strike through the entire page and initial at the top. If you do not wish to receive life-prolonging measures, or if you wish to limit what types of life-prolonging measures you receive, you should complete this page. Paragraph 1 allows you to decide under what conditions you want life-prolonging measures withheld. If you have a condition that cannot be cured or will result in your death shortly, If you lose consciousness and your doctors determine that you will never regain consciousness. If you suffer from dementia and your doctors do not believe that you're going to get better. You can initial any or all of the three choices. Paragraph 2 allows you to state affirmatively that you wish to receive artificial nutrition and/or artificial hydration. You may initial one or both choices. Paragraph 3 states your wish to be kept as comfortable as possible. You do not need to initial this paragraph. Paragraph 4 gives your permission to your healthcare providers to carry out your wishes with regard to withholding or discontinuing life-prolonging measures. Again, you do not need to initial this paragraph. Paragraph 5 applies only if you have named a healthcare agent in Part A or through a separate document. If you have named a healthcare agent, you may choose to allow or not allow your healthcare agent to authorize the use of life-prolonging measures. If you do not want your healthcare agent to have the ability to decide whether to use life-prolonging measures, you should initial the first choice. If you do want your healthcare agent to have the ability to decide whether to use life-prolonging measures, you should initial the second choice. You should initial only one of the two choices. Part C is titled, Completing this Document. In order to be effective, your healthcare power of attorney and living will must be properly signed, witnessed, and notarized. You must sign your healthcare power of attorney and living will in the presence of two witnesses and a notary public. Do not sign it ahead of time. The notary public and your witnesses must watch you sign the document in person. Paragraph 1 is where you sign and date the document. Paragraph 2 is where your two witnesses sign and date the document. Your witnesses must not be related to you by blood or marriage, and they cannot be entitled to inherit property from you either by law or under a will. In addition, the witnesses cannot be your healthcare providers or employees of your healthcare providers. Paragraph 3 is where the notary signs and seals the document. The notary swears or affirms that he or she witnessed you and the witnesses sign the documents. Once you've completed and signed your healthcare power of attorney and living will, you should place it in a safe place and let your healthcare agent or family know where to find it. You should make copies and provide them to your healthcare agent, family or close friends, and healthcare providers. You may register your healthcare power of attorney and living will with the North Carolina and National Registries. You may have to pay a fee. Here are the links. For the North Carolina Registry, go to www.sosn.gov/AHCDR. For the National Registry, go to www.uslivingwillregistry.com. You are not required to register your document. The benefit of registering your healthcare power of attorney and living will is making it available to other healthcare providers and institutions if necessary. You should review your healthcare power of attorney and living will once a year to make sure it's up to date and accurately reflects your wishes. If you live in eastern North Carolina, you also have the option of registering for Vidant Health, which is a healthcare network that will share your legal documents with any provider in the Vidant network. Instructions for registering are on page 9 of your toolkit. If your medical provider is not in the Vidant Health network, you can check with them to see if they have a similar registration system for these documents. Not all healthcare providers maintain this sort of registry. If you later decide that you no longer want a healthcare power of attorney and living will, or if you wish to make changes to your healthcare power of attorney and living will, you may revoke the document at any time, so long as you remain competent. If you wish to revoke your healthcare power of attorney or living will, you may do so by executing a written revocation or by executing a new healthcare power of attorney or living will. In addition, you may revoke by expressing your intent in any matter that effectively communicates your desire to revoke your healthcare power of attorney or living will. In order for your revocation to become effective, you must communicate your intent to revoke to both your healthcare agent and your attending physician or psychologist. There are other types of advanced directives that you may wish to consider using. The first is called an Advanced Instruction for Mental Health Treatment. This form allows you to make decisions about the use of psychoactive medications and admission to treatment facilities. You may obtain this form from the website of the North Carolina Secretary of State. Go to www.sosncd.gov/ahcdr/forms.aspx. You may also want to consider having your doctor sign a medical order for the scope of treatment and/or a do not resuscitate order. These forms are available from your doctor. This concludes our presentation today. We hope that you found it helpful. Thank you.